ийм уушиг хэлцээс сайдын зөвлөгчид маш баярлалаа. За одоо бид үндсэн бүлгийнхаа үйл ажиллагаа руу орж байна. За манай хамгийн ихний илтгэлийг одоо аутентик акт үйлдэхдээ эмзэг бүлгийн оролцогчдын эрхийг хамгаалахад нотариатчийн үүрэг гэдэг сэдвээр холбооны 24 онсын холбооны нотариатын техникийн дэдгэрийг хэлчихсэн. Олон улсын нотариатын холбооны өдөр тутмын зөвлөлийн гишүүн тус холбооны хамт ажиллагааны комиссийн дэдгэрийг хэлчихсэн. Ноён Бог, Эрхийг Бог хэлдэг байна.
Dear Presidents, dear members of the Quorum, ladies and gentlemen, dear colleagues and friends, the notary's role with regard to protecting disabled persons, minors, elderly persons, whom I will refer to in the course of my speech as vulnerable persons, has been a popular topic at the UNL for quite some time now. The organizers of this morning's event have allowed me to put the matter of material work concerning vulnerable persons into a wider context. In most of the material codes of the UNL member states, there is a regulation according to which notaries are duty-bound to protect inexperienced or inexpert parties from disadvantages. That is, as it were, the general clause protecting vulnerable persons is only one aspect of this. I would like to take this opportunity today to outline the official duties of German notary where vulnerable persons are involved. There are cases which occur from time to time in our work, but I cannot say frequently. I will then take the liberty of considering further aspects of this wide-ranging subject, namely those which are part of our day-to-day business. The center around the general official duties to protect the weaker party and in particular the compliance with the regulations governing consumer protection. The symbols are the regulations which the notary has to follow when it concerns the participation of physically disabled persons, which means persons who cannot see, hear, speak, write. Different regulations have been established for such situations in the various countries. For example, the participation of witnesses, another notary, etc. Such additional requirements are dispositive in Germany, that is to say, they are optional for the person concerned. The matter becomes more difficult if the notary has reasons to doubt the legal competence or contractual capacity of a party. In such case, the notary has to ask the person concerned to present a medical certificate issued on the day of the notarization. According to the ruling of the German Federal Court, Federal Supreme Court, a medical certificate from simply any doctor is not sufficient. In such cases, it must instead be issued by a neurologist. If the doctor is unable to testify the legal competence beyond any doubt, the notary has a problem because legal competence can no longer be established ex officio by the authority in Germany by virtue of one's official position. If a person is no longer able to arrange its legal affairs, he or the family members can ask the court to appoint a carer for this position. The carer signs the legal document instead of the person, But this does not make it valid yet, for in all these cases the court's approval is still needed. If, for example, a person under care sells a property, the document will not become effective until the court has approved the sale. The process for obtaining approval of the court is lengthy. Such processes also cost money. It was with this in mind that the Federal Chamber of German Notaries started to propagate the idea of setting up special powers of attorney, so-called precautionary powers of attorney. Precautionary power of attorney needs mostly a lease certification of the grantor's signature. It gives the person or persons named to either one granting the power of attorney the right to represent the grantor in the event of there being doubts as to his legal competence. Such precautionary powers of attorney are all entered in a special electronic register at the Federal Chamber. In addition to the notaries, all the courts have access to this register too, and it can therefore be verified in any particular case if such a power of attorney actually exists. To date, 3.5 million of such powers of attorney have been entered in this register. It is it's a real success story. Notarizing precautionary powers of attorney is fortunately only a marginal part of our work. Our wide-ranging competences focus mainly on real estate law, company law, the law of inheritance, and family law. Under our Notarization Act, we are obliged to make sure in all authentications that any inexperienced and inexperienced the parties are not disadvantaged. The law does not say anything else on this matter. Nevertheless, this requirement standardizes primary duty of the notaries, and not complying with it constitutes a breach of official duty and may lead to claims for damages against the notary. There has been a substantial number of court rulings over the years concerning this issue. I would like to give you two examples. According to our civil law code, it is possible for couples to enter into a marriage contract before or during their marriage, in which the legal consequences are regulated should they ever get divorced. Such a contract typically deals with rights to the adjustment of assets unequally divided, post-nuptial maintenance and participation in the mutual rights to draw a state pension. It is not forbidden under this law to completely exclude these rights in the event of a couple getting divorced. Nevertheless, the German Supreme Court has ruled that excluding such rights is invalid if the weaker party, which is usually the wife, is unreasonably disadvantaged by this. If the couple's arrangement is that the wife should not go out to work, but should instead look after the children, such a marriage contract will be completely, partially invalid in the event of divorce, if the wife did not manage to enter into gainful employment. This applies in particular if the circumstances at the time the contract was signed suggest that the disadvantaged spouse was under certain pressure. In the past few years, we have seen a relatively large number of migrants coming to Europe from the Middle East and from Africa. Some of these migrants have married German citizens, perhaps motivated by the right of residence, which they would then enjoy. Marriage contracts, which in the event of divorce provide for a restriction for the foreign spouse, may then be invalid because they were concluded against the background of imminent eviction. This is also true for the relatively frequent case where a marriage contract is concluded at a time when the wife-to-be is pregnant. The standard question each and every notary asks engaged couples wanting to conclude a marriage contract is whether they are already expecting a child. If they are, then he sends them home again and waits until they are married before proceeding with the notarization. The situation for the notary is happily better when it comes to real estate contracts, because everything is regulated by law. The most common situation where it is necessary to protect inexperienced people from disadvantages is the purchase of apartments which haven't been built yet. Several years ago, when I was in Romania training for notaries, I was called to the Minister of Justice. He told me that the notary had authenticated 60 contracts for sale for apartments which were still to be built in the center of Yerevan. The property developer pocketed the full purchase price in cash, and then, once the last flat was sold, it disappeared with all the money. What do you need notaries for in this country? The minister asked me. I replied that the notary had probably breached his duties to provide information and to point out any risks, because what was involved was actually a completely unsecured advance payment for a contracting party. I explained that that was not really the core of the problem, however, and that what was needed were statutory regulations specifying at what stage of the construction process the property developer is entitled to demand fixed percentages of the purchase price. It may be the notary's duty to protect the weaker party from disadvantages, but he can only fulfill this duty through specific instructions, precautions, and warnings. The Supreme Court, our Supreme Court, has set out in specific terms the duties of notaries to instruct and to caution where unsecured advance performance and payments are concerned. It is not only the notary's duty to point out the dangers and risks, he must also present solutions which reduce the risk for the weaker party to the contract. According to the law, as it now stands, the notary in the Romanian case would then have been obliged to point out the possibility of depositing the purchase price, or that the seller be required to provide bank guarantee. It is, of course, better if the legislature itself takes the initiative and stipulates the maximum part payments, which the buyer may pay for properties which still have to be built. We have had such a law since 1974. Losses on a larger scale have not come to light. We have already come to the last topic of my address, that of consumer protection. Consumer protection is a matter of fundamental concern in the German notary profession. In fact, in the very German judicial system itself, as it is evidenced by the full name of our Federal Ministry of Justice. This is the Federal Ministry of Justice and Consumer Protection. In nuanced societies with complex economic structures, confusingly ordered markets, and great difference in economic power and experience, the factors which an average citizen bases his economic decisions on are becoming ever less transparent, ever more difficult for him to understand. He often doesn't make his decisions rationally, but based on particular preferences, advertising, and the persuasive powers of other players in the market. Our legislators see it as the duty of notaries to help the less experienced contracting party to come to a decision which is as rational as possible. We cannot urge or caution the parties to behave rationally, of course. When they make their decisions, they are exercising their basic right of private autonomy. We see, however, that in confusingly ordered social and market structures, there is a need to support the weaker parties when they are exercising their rights under private autonomy. To this end, there are both statutory regulations and legal precedents which entrust as notaries with these social political duties. After all, our obligation to formulate preventive contractual arrangements to avoid conflicts is one aspect of the task to preserve social peace, given our profession within the framework of legal policy. When consumer contracts are involved, these are contracts between a businessman and a private individual. The notary has a duty to prevent any arrangement proposed by the businessman which would give him a one-sided advantage. A number of such arrangements are regulated in detail in our civil law. It is not possible, for example, to oblige the buyer of an apartment which has just been finished to pay the full purchase price, although defects may be discovered when the contract is signed. Nor is it possible for the purchaser to waive warranty claims or to agree to reduction of the legal warranty period of 5 years. Our Notarization Act has imposed obligations on notaries which go even further. Notaries may only authenticate such contracts if the consumer has received a copy of the draft at least 14 days before the notarization is to take place. This is designed to give him the opportunity to examine the draft, to give him time to reconsider his purchase decision and, as the case may be, even to abandon his plans. The consumer cannot even say he does not wish to stick to this period. It would be not valid. If the notary completes the authentication before the period is over, then the purchaser can prove that he would have decided against the purchase if the 14-day period had been observed. The notary renders himself liable to pay damages. If the notary is found to have disregarded the period stipulated on several occasions, it will result in his removal from office. I have now to come to the end. In 2004, the member states of the UNL adopted a regulatory framework called Deontology and Rules of Organization for Notaries, a sort of code of notarial ethics. According to this code, have notaries to reject any acts which, albeit with the law, are contrary to their spirit, or any acts that are overtly detrimental to the parties. One article defines this principle more precisely, specifying that notaries shall pay special attention to the party who needs the most information by offsetting any imbalance in knowledge, actively offering their professional advice and opinion. This is basically to do with general principles of consumer protection, that is to say, protecting the weaker contractual parties. In an increasingly complex world, there is an ever greater obligation for notaries to make sure the parties fully understand the legal consequences of the agreements they make and to ensure that nobody is harmed or may suffer a loss in any way. That is the summary and quintessence of our social obligations. When we stick to the rules of our deontology, we can contribute a little to making our world a better place. Thank you for your attention.